Today's Cardinal lesson, see-through trust or trusts for IRA beneficiaries. And that's a mouthful. So you're an IRA owner and you want to leave your IRA to beneficiaries, a lot of times your children, your brother, whoever your beneficiaries are, but you want to leave it in trust for some specific reasons. And you need a special kind of trust, and you need to go to somebody that knows what they're doing and knows about this special kind of trust, or you're going to get in all kinds of problems tax-wise. So what we're going to do is talk about this. And the first statement that I want to make is that trusts and IRAs don't mix very well. So here I am just taking it away. So why are you doing a video on this thing if you're going to show me how to do a see-through trust for my IRA beneficiaries? And then the next thing you're telling me is that IRAs and trusts don't mix very well. Well, I'm going to tell you that an IRA cannot be put in a trust while you're alive, while the owner's alive. So the person who created the IRA needs to stay as an owner, and it can't be put in a trust while they're alive. It's only at their death or after their death that the IRA can be transferred into an IRA. And then if that into a trust, and if that trust is not a see-through trust, properly drafted, properly executed, then they're going to lose the benefits of creating the trust in the first place. So what I'd like to do is go to Tom, and I want Tom to share, like, why are we doing this video?
Yeah, I mean, we're doing this video because we see it all the time. And maybe you've done this where you've gone to an attorney, they set up a trust as part of an estate planning plan, which can be useful, but they're not really aware, you're not aware of how IRAs interact with trusts. And oftentimes it sets things up in a way that are going to be disastrous for whoever the beneficiaries of the trust are. And so you really need to know how these works, how to set these up properly. And like Han said, trusts and IRAs really just don't mix very well together. And so we just want to make sure, we want to make you aware of it. If you're going to do it, we want to show you how to do it the best way. And at the end of the day, we're probably going to try to talk you out of doing it if there's any other way to complete your plan without having to put the IRA money into the trust. So let me bring up the show notes here. You can find these on the link below our video. They're also on our website. Today is pretty light on the show notes. We just have the board. Again, you can print it out. You can take notes on it, look at it a little bit bigger. But what we'll do is we'll turn it back to Hans and the board, and we'll sort of go through each of these different pieces, advantages, disadvantages, and the like.
Okay, and advantages here could be also reasons. Like, what would be the reasons why you would want to do one of these? And the number one is post-death control. Some people want to be able to control how their kids or grandkids or sister or brother or whoever the beneficiaries are, they want to use a trust to control how they spend the money and how they pay taxes, that sort of thing. As opposed to just leaving them as a beneficiary, they get the money and then they're able to do whatever they want with it. So if you have a desire for post-death control over the money in an IRA, then you need to learn about these things and do them right. Second reason is protection from creditors. So this could provide, the trust could provide another layer of protection so that if you're worried about your kids, your adult kids, or maybe your adult kid's spouse, and you're worried about them getting into some kind of financial trouble, and then this money you're leaving them would be subject to the creditors, this would provide another layer of protection. Or just flat mismanagement, is if you're concerned about how your kids spend money or how they pay taxes, how they plan. You can use a trust to just stipulate the terms. And, with the see-through trust, it's going to be, you're going to stipulate the terms are going to be set up according to the beneficiary rules for RMDs. Okay. And then the third thing is for special needs planning. And this is the area where we actually set up a lot of these, and because if you leave money directly to a special needs adult child at your death, then receiving that money could kick them out of all their government benefits, which are really necessary for somebody that has autism or whatever their situation is. Now they have to live on from 45 or 50 on without their parents who've been taking care of them all of their life. And you provide for all that and you're going to pay for all that. You're going to do that through a special needs trust. But if you just stick IRA money into the special needs trust by beneficiary, you could run into problems. And so a separate see-through trust that is going to allow this special needs child or the trustee to spread these things out over their remaining life expectancy. So this is an area where we do recommend them quite a bit and actually use these things. So the disadvantages of any trust, and specifically complexity and cost, is you're going to pay a lot to get a trust set up, and then to have somebody have a trustee managing this thing over time. I mean, that doesn't necessarily need to scare you off. And people that are of greater wealth, who perhaps have other trusts set up anyhow, that this cost is not that big of a concern for them, but we just want to have that up there. The tax implications, if you mess one of these up and the money goes into the trust and it's not set up properly, it's all going to be taxable. The money is going to come out of the IRA and it's going to be at trust tax rates, which are up at a lot. The thresholds for them get you at the 37% level very quickly. And then beneficiaries must qualify as eligible designated beneficiaries. So I want to bring Tom back on, and I want Tom to talk a little bit and make this stuff, the pluses, the minuses, you want to make that a little bit more real.
Yeah, so let's talk about like what is a see-through trust. Like we've been talking about this, and so really sort of by definition, what this does is it passes the income through the trust to the beneficiaries of the trust, and the beneficiaries are the ones who pay the tax on the income. And so the reason that that is more beneficial with IRA money is, like Hans mentioned, the trust tax rates are extremely high. You get to that 37% bracket very quickly. And so what you want to do is you don't want to have worked all this time, saved all this money in the IRA, to then have it all get spent in taxes at the trust tax rate. So the benefit of that see-through trust is having it, the income go through the trust. It's peering through the trust, looking through the trust to the beneficiary, and the taxes are paid at that beneficiary level. So that's sort of why you want to do it. One of the problems you run into with IRA money is it's set up that way. The RMDs are coming out. You have that if they're an eligible designated beneficiary, they have the 10-year rule that they have to worry about, or a non-eligible designated beneficiary, excuse me. The non-eligible designated beneficiary has the 10-year rule. They have that 10-year rule they have to worry about. At the end of that 10th year, it all gets distributed out of the trust, sent to the child. They pay the tax in that 10th year, and now that money is outside the trust. So you've lost the post-death control. You have bought yourself 10 years after death to have some control over it. But that really isn't generally the goal, is to not then just give it all to the kids in the 10th year. So that's a problem if you don't use a see-through trust. So now we're going to get into why does it even need to be a see-through trust. As a non-see-through trust retains the asset, the IRA holds, or the trust holds the IRA. It has to still make the distributions. It now falls into the non-designated beneficiaries, which is under a 5-year rule. So now we've really even further accelerated the distributions out of the trust, and they are being paid at the trust tax rate in that situation. And you can leave it in there, but now you're really paying a whole bunch in taxes to keep it inside the trust. So if the goal, again, depending on your goals, and this is really where we want to start with each person and listen to what they really want to accomplish. Oftentimes there are better ways to accomplish what they're looking to do so, rather than leave traditional IRAs or really even Roth IRAs into a trust. And so, like Hans had mentioned, normally we want to try to remove the beneficiaries of IRAs as the trust. If there's a real neat reason to do it, you need to make sure it's done properly. You need to work with attorneys that are really aware of all this. Unfortunately, a lot of attorneys don't really know the intricacies of how this works. They're really good at writing the legal documents, but they have no knowledge of the tax implications, how it's handled with IRAs. So you really need to get with an attorney or maybe a team. Oftentimes we will refer people to attorneys that can write the trust, because we don't write the trust, but we can at least tell them how it needs to be written. and work in conjunction with them to make sure it's done properly. So you just need to have a plan around this. You need to make sure it's done right, because when it's done wrong, sort of by definition, you don't know it was wrong because you have died when all this is playing out, and it can really cause a whole lot of problems and really blow up the whole estate plan if not done properly. So just you need to be thoughtful, work with professionals who knows what they're doing to make sure it's done right.
Now, this section right here is more for the attorneys, but in the interest of the presentation, see-through trust requirements. So I don't want anybody to take this and try to bring it to an attorney or do one of these things on their own. But number one, it's got to be valid under state law, which is any trust. But under the IRS guidelines for these see-through trusts, this is number one. Number two is it needs to be an irrevocable trust. So we can't just end the trust. It needs to be have identifiable beneficiaries, because this is the whole link, is that these beneficiaries are going to get the same RMD requirements, required minimum distribution requirements, that they would get if the money was just left directly to them. So you need to have clearly identifiable beneficiaries. And then number four, the documentation needs to be sent to the custodian by 1031 following the IRA owner's death. So those are just some general guidelines. And, we run into this a lot where we discover the problem where people have this set up where they're leaving the IRA to a trust and they haven't followed all this. And so we're going to undo that. And generally, we're going to refer them to an attorney that is a specialist at these see-through trusts for IRAs. And we have several attorneys that work in several states by Zoom and who are experts on this. So if anybody's interested in that, we can make a referral on that. And then I really want Tom to talk about, this is the list of recommendations. If you do implement one of these things, how you're going to go about it.
Yeah, so I mean, this isn't all encompassing, but these are just really general guidelines that we want to follow. Is you need to consult with a professional, again, an attorney, someone like us who really knows how these interact and can set it up properly. Oftentimes, that can look like setting up two separate trusts: one that just handles the IRA, one that handles everything else. So again, that's just I'm not a lawyer. The attorney would need to sort of draw those up, but that is I've often seen it done that way. You need to review regularly. Again, tax law changes, things change. Just as an example, trust written prior to the Secure Act, which was passed leading into 2020, probably worked fine with IRAs. After the Secure Act, the language in there, because the Secure Act wasn't law yet, just doesn't work with what the intended plan was. So you need to update regularly. Again, use professionals to do that, and you need to consider the tax implications. I mean, a lot of the reason you don't want to use IRA with trust all comes down to the income tax and the trust tax rate that trusts have to pay is that they're just extremely high. You've worked this hard to save this money, not pay taxes on it, to then spend it all in taxes, again, generally is not what most people are looking to do. So you need to do those things, review them regularly, work with professionals, and consider the tax implications, really to make sure that your plan is being thought out and utilized and executed on. Because again, the trust comes into play after you are dead. So you don't have any chance to change it, to change course at that point. It's set, it's going to play out the way it's going to play out, and you have no control over it after you're gone. So you need to do the thinking now while you're still with it. You can still make the changes if they need to be made.
So if you call us, I want to kind of close on a point. If you call us and ask for one of these, we're going to probably first try to talk you out of it and just leaving the money directly. And what we're going to get out of you are the reasons that you want to do it. And if we see strong enough reason to do that with you, then we'll make the proper referrals and we'll set it up that way. But just caution, IRAs and trusts don't mix well, okay? Now, I want to go over in this scope of complex financial planning, or comprehensive is the actual proper word. What we've touched on today is 401k and IRA. We've touched on income for the beneficiary. This whole video is about estate planning and planning out how the money is going to flow to the next generation and what, then what the taxes are. So Tom's already back on. I'm Hans Scheil,
And I'm Tom Griffith.
and we thank you very much for listening.
Thank you.